are talking today about the Colorado Real Estate Commission's position on disclosure of adverse material facts. I have 5 things to say about this position today. Not 4, but 5 things to say about this position. The first thing is that it is a very important topic, and we appreciate the Colorado Real Estate Commission for attempting to bring clarity to it. It is also a vast topic about which we could talk about for a couple hours easily, but we're going to try and limit ourselves to 10 minutes here. One of the things that the commission position makes clear at the beginning is brokers should refrain from advising clients about the client's disclosure duties, which may be different from the broker's disclosure duties. I very much agree with the spirit of that comment. As a lawyer who defends real estate brokers, one of the most common things that we see that gets real estate brokers in trouble is where real estate brokers give the impression to sellers, or sellers get the impression that their real estate broker has told them that the seller does not need to disclose things. When in doubt, disclose. When the question comes up, disclose. I would have phrased it a little bit differently. I would have phrased it, brokers should refrain from discouraging their clients to disclose. And if their clients are not inclined to disclose, the broker should advise the sellers to consult their own legal counsel. Don't worry, brokers. Sellers probably won't talk to their own attorney. Thank goodness for me, because if they did talk to their attorney would advise them to disclose. But it is such tremendous risk reduction for a listing broker to advise the seller to talk to their lawyer about disclosure issues. Okay, that's number 1. Second issue, there's an age-old question about what is an adverse material fact that needs to be disclosed. Now, what is pretty clearly settled in the state of Colorado is that adverse material facts include things that touch and concern the physical property. Things like property condition issues, things like title issues, things like zoning issues that touch and concern this specific property. But one of the age-old questions about disclosure is, what about stuff that's going on off-site that doesn't really touch the property, but may still affect the buyers of this property? In an ideal world, the Division of Real Estate would have given us some examples of some things that did not need to be disclosed, and they haven't done that. In an ideal world, the Division of Real Estate would have given us a theme for some things that don't have to be disclosed, and they haven't done that. Examples of questions that come up are, what about the football field next door that has lights that go on, that shine in the window? What about the barking dog that lives next door? What about the neighbors from hell that lives next door? What about the environmental contamination down the street, and we don't know whether it's seeped underground and affects this property? What about the convicted child molester who lives across the street from the property? This position doesn't attempt to address any of those things, but it does give us a little window into what the commissioners are thinking, because all of the examples of things that need to be disclosed are things that touch and concern the physicality of the property. It gives us the examples of things that affect title, things that affect the condition of the property, environmental hazards affecting the property. It gives us some other examples: building and zoning violations, water damage to the flooring of the property, marijuana plants, structural damage to the home caused by insect infestation, or expansive soils, or a lien against the property. Again, things that affect the physical condition of the property, the title, or the zoning. There's another sentence in there: to the extent a broker is unclear about whether a known fact that affects the physical condition of the property is adverse or material, the broker should err on the side of disclosing. But that sentence is limited to things that affects the physical property. Not something that any of us can go to the bank on. If you are tormented, if you have any doubt about your disclosure obligations, Or I'll put it another way. If you're inclined not to disclose something, talk to a lawyer, talk to somebody who doesn't have a commission at stake in the transaction to get some perspective on it. That's the end of number 2. Our third issue related to this is psychological impacts. In Colorado, we have a statute that says that brokers do not need to disclose things, at least listing brokers, sellers agents, do not need to disclose things that merely psychologically impact the property. It's inherently ambiguous to define what is something that merely psychologically impacts the property, and the statute gives some examples. The statute makes it clear that they are merely examples because the statute has language in it that precedes the examples. The statute says that adverse material facts include but are not limited to, and then goes on to give 2 examples. And those 2 examples are essentially that an occupant of the property had AIDS, and the second one is that there was a homicide, a suicide, or another felony committed on the property. Something that I think is unfortunate about this position is that it purports to limit the characterization of psychological impacts to those 2 kinds of examples. And that doesn't make sense to me in light of the fact that the statute uses that includes but not limited to phrasing. That is, it's unfortunate because the statute makes it clear that the examples that the statute gives are exactly that, merely examples, which means there are other things that are psychological impacts that brokers need not disclose. That's number 3. The 4th thing, I guess I've already mentioned this, I'll mention it again. The position would have been especially useful had it identified examples of things that brokers do not need to disclose. The 5th thing is the position does not address the scenario where the broker and the seller disagree. There will be situations where you, the broker, clearly know you have an obligation to disclose something and your seller doesn't want you to do so. Now, the theory is that the state law trumps your duty to your seller, and in your listing agreement in Colorado, the seller has consented for you to disclose these adverse material facts. And so, by all means, disclose these things to the other side in direct contradiction of your seller's direction. But the real world is more complicated. Number 1, sometimes there's judgment calls, and you may be overzealous about disclosing. The other thing is even if you're clearly correct, it's generally not good to have bad relations with your client. So I don't have a general rule for you. You need to address that scenario case by case where you and your seller have differences of opinion. And I'll make the self-serving comment. You should address that case by case with your own lawyer. Those are the 5 things I wanted to say about the Real Estate Commission's position number 46 on disclosure of adverse material facts. Remember, the nature of something like this is we can't comment. We can't take the time to comment about all the great things about the position. Keep that in mind. Let's be gracious as we interpret that. And remember, it's a complicated world. Be careful out there.